Okay, Shannon, you can put us on the record now.
Okay.
This is the matter of LeMay versus Beverly, and I'm going to need each of you to identify yourselves for the record.
Stephen Sinus on behalf of plaintiff Jeanette LeMay.
Joel Ashton for defendant Smith.
Ryan Tactac for defendants Allen and Charles.
Okay, and this is defendant Smith's motion for summary disposition, correct?
That's correct, Your Honor.
All right, I have read all of your submittals. Please go ahead and tell me what else you think I need to know to rule on this matter.
Joel,
Yeah.
Before you start, I'm sorry, I don't want to interrupt. There's just one procedural thing, Your Honor, and maybe this didn't come across to you before this hearing, but we filed a motion for leave to file a response brief that was noticed up for the hearing today as well. And so I just didn't know if it made at all sense to start with that issue. Perhaps the court already read it. I just trying to make a record here that we did have another motion filed for our ability to file a response to Mr. Ashton's reply brief.
Wow, our reply is better than I thought.
Any reason you can't just simply respond on the record to that?
I absolutely can do that, Your Honor. I just wanted to make the note. So thank you. I can do it
All right.
that way.
Yeah, let's do that. I'd like to get this done today if I can. Go ahead, Mr. Ashton.
Thank you, Your Honor. Your Honor, as you indicated, I know that you've read our briefs. We were very detailed in both our brief and our reply. I just want to emphasize really 2 or 3 points from our argument. One is that under the Recreational Land Use Act, which clearly appears to apply to the facts of this case and to grant immunity for Mr. Smith, the plaintiff's response is essentially that the plaintiff's primary purpose on being on the land was not the recreational use of the land, or more specifically, I believe, to make use of one of these off-road vehicles, but was more generally speaking to just attend a party, and that she happened then to participate in an activity on this UTV. We noted in our reply that the Court of Appeals has already addressed that very same argument in the ROTT case, R-O-T-T. And in that case, the Court of Appeals found that the primary purpose of being on the land does not have to be the recreational use of the land, and rejected that argument. The other general argument that plaintiff seems to make really goes to the general, to the social host liability doctrine that applies to this case. And plaintiff, I think, wants to take issue with the fact that Mr. Smith should have liability because alcohol was being served to people that he knew would be using vehicles on his land in this case. The problem with that argument, Your Honor, is that when you take a look at this case, plaintiff is throwing a lot of facts and details to try to take us away from the primary legal argument, which really is the fact that social host liability doctrine in this case bars liability for Mr. Smith. This is a case in which there was a party. This is a case in which alcohol was served, but most significantly, the alcohol in this case was being served to adults. There are case after case after case in Michigan which indicates that there is no liability for the host of such a party and for the purported or alleged negligent serving of alcohol in Michigan, as long as the alcohol is being served to an adult. And that's what the case is in this matter. Plaintiff attempted to distinguish the 2 cases that we cited, the Kuhn case, I think that's K-U-E-H-N, and the other one was Leschinski, L-E-S-C-Z-Y-N-S-K-I. With those cases, and in those cases, plaintiff wants to claim that the cases that we cite are distinguishable because the case law shows that for social host liability to apply, alcohol needs to be served, and then the intoxicated person needs to leave the premises and then injure a third party elsewhere. That is not the law. There are no cases cited by the plaintiff which supports that. And we were unable to find any cases which support that. And in fact, the two cases which he attempted to distinguish had to deal with facts where owners of an apartment complex were charging for attendance at a party. And another, the Lashinsky case had to deal with a host in a hospitality room at an event at Cobo Hall, where there was a question about whether or not the person that was attending was really attending as a social host. The fact is, when you get to the very basic facts of this case, we're dealing with an adult who was unfortunately injured at a party, but the claims against Mr. Smith as the property owner and as the social host are properly barred. And for that reason, that's why we filed our motion for summary disposition.
So you don't mention in your motion the doctrine of assumption of the risk. I acknowledge my familiarity with that particular doctrine probably goes back to my law school days, but if ever there were a case where you would be tempted to say, you know, she's going to a party knowingly where alcohol's being served. She's going there because she wants to imbibe an alcohol herself. She knows alcohol's being served to the driver of the ATV or four-wheeler, whatever this is. She knows he's been drinking, and she willingly gets on this. Does the assumption of the risk doctrine have any vitality in the state, or is it just an affirmative defense and comparative negligence?
Yeah, I think your point is well taken. We did make reference in our motion to the cases which use the terminology wrongful conduct rule. My thinking on assumption of the risk is I think it does apply, but it started to sound a lot like we might need to delve into the facts in the case. And in order to file our C7, C8 motion, frankly, to avoid the expense of staying in the case long enough to present even more facts about this party to the court, we decided to go with basically the argument of immunity. But I do think that you're right. And I think assumption of the risk will apply. And tangentially then related to that, I think it's significant in our case that the owner of the UTV and the driver of the UTV are still involved in this case. It's not a case where there isn't any potential recovery should something like assumption of the risk not completely bar potential recovery.
Thank you. Mr. Sinus?
Yes, Your Honor, thank you. There are a couple of fundamental points I need to make here. The first one is that we are just at the start of this case. And so dismissing this case right now with no discovery at all is, I think, would be the flaw here in terms of reaching any conclusion one way or the other, because we need to know more specific facts about how this all occurred. With regard to the facts that we've alleged, it is not the case that my client knew that Ms. Landers was intoxicated. She alleged that she did not know that. She alleged that Mr. Smith did know that, and so did Mr. Charles. She was also in a situation where this UTV was put on the property as a result of the party and the planning for the party between the two social hosts. and then she got into the UTV, and then of course that's when her serious injuries were sustained. With regard to when this occurred, it occurred with her being at the party for less than or about 2 hours, and the ride that she took on the UTV was a ride to go to other parts of the party. So this gets at the RUA argument, and this is my next fundamental point about the RUA issue. First of all, as the court may or may not have seen in the response brief that we tried to file in response to their reply brief, the Rott case is a case that they are saying pretty much totally destroys our argument. The first point for the court to be aware of about Rott is that it is pending before the Supreme Court, or the Supreme Court has actually taken the case in an order dated November 2020, and it is specifically addressing the issue that the Court of Appeals decided regarding the interpretation of "for the purpose of." So this is a live issue that the Supreme Court has taken. Defense counsel did not make that point in their reply brief. And so if anything, if the Rott case is going to control the analysis here, that's where my response brief asked for this court to consider holding the ruling on the RUA in abeyance and allowing us to proceed and actually have some discovery. And so when you're considering Rott, I also want to make a few more points about the specific factual pattern in Rott. It had nothing to do with the UTV. It had to do with zip lining. And there was a zip line system at a landowner's property, and they were hosting a party. And then the factual summary of the case indicates that at some point the person left the party to go zip lining. Here we have UTVs, which are not zip lines, and it's part and parcel of how this party's being thrown. And so when you're looking at what the court was considering in Rott, you have an issue where they were considering how the initial reason for being the property was to go to a party, and then it changed over to go ziplining. Here, she was not going to the property to ride UTVs. She came to the party and was there for 2 hours, and then she was offered a ride by one of the co-host girlfriends in the co-host vehicle to go to other parts of the property. So when you look at the RUA, it is an act that is intended to promote tourism for recreational purposes. The case law is very clear. And what Mr. Smith is trying to do is use the RUA to shield himself from liability for throwing this, what is known to be as a wild party. And the wildness of the party is something that we can explore through further discovery. But it's not the intended purpose of the RUA to protect him in this situation, nor was it the activity that my client was seeking to pursue. So this RUA issue is one where I believe that with the pending Supreme Court decision in Rott that's going to squarely address the argument that Mr. Ashton is relying upon, and given that we've had no discovery, holding it in abeyance and allowing discovery to occur so that we can have a more complete factual record would be the most prudent way for the trial court to handle the issue at this time. So that's my argument with regard to the RUA. With regard to social host, to kind of take what Mr. Ashton said and put it another way, he has not presented any case to the court that says that somebody who hosts a party on their own property and lets adults get heavily intoxicated and then drive vehicles around on that property and hit other party guests or injure other party guests, that host is immune from creating that circumstance. There's a bunch of cases that deal with the acts of party goers after they left the party, then trying to pin the liability back on the social host, whether it be a venue or a person who hosted the party. But it's not this factual pattern. And there isn't a case that has been cited that takes out the argument we're making in this case, where by creating this situation of drunken adults driving party guests in vehicles around the property, subjected my client to an unreasonable risk of harm. So the social host theory is also one that deserves further discovery to determine the extent to which alcohol was authorized to be drank, the extent to which vehicles were allowed to be driven, so we can have a more factual record to determine the active negligence of Mr. Smith in creating this atmosphere. So that summarizes why the case should I think stay intact. I should make the other point about gross negligence. I guess this relates back to the RUA. if the court is going to accept the arguments that the RUA insulates Mr. Smith from all acts of negligence, he can still be held liable for acts of gross negligence. And again, we've had no discovery in this case. We're just trying to take some depositions. So it all comes back to the need to create a complete factual record. There are nuances within this case, the unique circumstances, and there's so much with the case law with regard to the specific facts and circumstances mattering that it would be premature for any ruling to be issued on these matters at this time.
Thank you. Anything further, Mr. Ashton?
Yes, so just briefly, Your Honor. The fact is that we're dealing with an adult plaintiff. Mr. Sinus seems to take issue with the Recreational Land Use Act and also with the social host liability in Michigan. But the fact is that the case law is very clear that liability for negligently furnishing alcohol does not extend to social hosts who serve alcohol to adults who subsequently injure third parties. That's the fact of our case. This idea of having negligently throwing a party for adults simply doesn't exist in Michigan. There is no such duty. As far as the Recreational Land Use Act, generally, the facts of this case fit squarely within the plain language of the statute that we cited in our case. And we discussed in our brief the fact that the gross negligence exception to the RUA has not been pled and does not apply in this case. The case law is clear that gross negligence would require that Mr. Smith had engaged in behavior subsequent to the plaintiff's own negligence to endanger her. And that's simply not the case here. We're dealing with an adult who chose to be a passenger in the dangerous activity of riding in a UTV in the dark at night in undeveloped property. And frankly, we don't think that any additional discovery is required in regard to this case for Mr. Smith. And we think that Mr. Smith should be dismissed at this time.
Your Honor, may I respond at all?
Briefly.
I just want to make a real clear point. We did plead gross negligence. It's in our complaint. We made that point in our response. And that was the only simple point I just wanted to clarify.
The words are there, correct?
Thank you, gentlemen. I don't think I can grant summary disposition under C7 or C8 based essentially on the pleadings. So I think that really brings us to C10. I will give you, for what it's worth, my assessment of this case from a common sense standpoint. Too often, the law seems to disregard common sense. The thought that somebody could knowingly go to a party, hop on a vehicle with somebody who'd been drinking and be injured and be able to recover for that, frankly, is repugnant to me. But the fact that the Supreme Court has agreed to take up this case, and knowing how our Supreme Court has for many years a propensity to look at the exact precise language of a statute and interpret it based upon the common sense of that language, it wouldn't shock me that the Supreme Court would say, you know what, this statute says if you're there for that purpose, then it's a bar. But if you're there for another purpose, and this also happens, then it's not a bar. I mean, it wouldn't shock me to see our Supreme Court strictly interpret this Recreational Use Act that way. Ultimately, I think plaintiff is entitled to do his discovery. We're early in this case. For purposes of a C10 motion, I think it would be premature, but frankly, I'll expect to see you back. I've told you what I think of the case. I'm not impressed, but I'm going to follow the law. At the end of the day, I would hope that common sense would rule. So I'm going to deny the motion because of discovery being ongoing. Mr. Sinus, you'll prepare that order.
Yes, I will, Your Honor. Thank you very much.
Thank you, counsel.
Thank
Thank
you.
you.
Okay, next up we have Hoffmeister versus the City of Jackson. And counsel, if you could please state your appearances.
Good afternoon, Your Honor. Philip Ellison appearing on behalf of plaintiff.
Good afternoon, Your Honor. Matt Granda also appearing on behalf of plaintiff as co-counsel.
Good afternoon, Your Honor. Matthew Haggerty, a Jackson City attorney appearing on behalf of the city.
Okay, Mr. Haggerty, this is your motion. I have read your briefs. You may assume that as you're making your arguments.
Thank you, Your Honor. And with that understood, I will be brief in summary of my arguments, but as the court's aware, this is the city's C4 based on lack of jurisdiction principally, and C8 motion based upon the plaintiff's failure to state a claim in this case. The motion was filed, Your Honor, on March the 10th in lieu of filing a formal answer to the complaint based upon jurisdiction, and that reason is simple. Your Honor, this is a city income tax matter, and for the reasons cited in my brief, which the court is familiar, exclusive jurisdiction over city income tax matters lies with the Michigan Tax Tribunal. More specifically, is referenced in plaintiff's own complaint at paragraph 29. This is a city income tax refund suit dressed in constitutional claims, but a tax refund suit nonetheless. The due process takings in unjust enrichment claims alleged do not change the fundamental claim, Your Honor, of the plaintiff, which is that he alleges he had city income tax improperly withheld and he wants a refund as a result. Even accepting those allegations pled as true, the mechanism for doing so, Your Honor, is found within Chapter 24 and specifically Section 24-1 of the city's Code of Ordinances, which adopts the relevant portion of the legislature's City Income Tax Act. That, as outlined in detail in the briefing, Your Honor, is the statutory framework upon which a claimant or an aggrieved party or a taxpayer in this case can seek redress by either going to the Income Tax Board of Review as a first step or to the Michigan Tax Tribunal. Section 93 of the Act, as I've cited in my brief, Your Honor, provides that exclusive jurisdiction and states that a taxpayer that's aggrieved by a final decision, assessment, or denial, or an order of the Income Tax Board of Review has their jurisdiction in their day in court before the Michigan Tax Tribunal. That exclusive jurisdiction is clear, and in reading the pleadings, Your Honor, it's also clear that the alleged action here is a decision or action alleged to have taken place by the city income tax administrator. So although plaintiff's counsel frames this as an appeal and makes an argument in that regard, that because this would be some type of an appeal, that this court would have jurisdiction and the tribunal would not, I think is specious. The reason being, Your Honor, there's two other sections of the Michigan Tax Tribunal Act that also provide exclusive jurisdiction, and those are sections 31 and 74 of the Tax Tribunal Act, 7 and 8 of the city's brief. So in addition to the three separate statutory provisions that provide the tribunal with jurisdiction to hear this case, Judge, there's also 4 published opinions that are directly on point, several of which deal with income tax matters. In fact, a case arising out of this very circuit court in 2000 involving Jackson Community College, dismissed a circuit court claim and found that a claim under the State Income Tax Act was properly filed before the Michigan Tax Tribunal because that tribunal had jurisdiction. The Honigman case decided just last year, dealing with situs of work, was also a case, Your Honor, that started before the Michigan Tax Tribunal. And the precursor to both of those cases is the Michigan Supreme Court's decision in the Wickman versus City of Novi case. That was a case involving an attempted class action suit that asserted constitutional claims. That was also dismissed for lack of jurisdiction and sent back to the tribunal. So what you have, Your Honor, is the notion of making constitutional claims does not thereby make a cause of action for which Your Honor would have jurisdiction. It doesn't divest.
So let me stop you for a minute, because I just want to make sure I understand practically what happens here. My understanding, I've been working from home as a result of COVID, so I'm not working in the city of Jackson anymore, but my employer's still withholding as if I'm a non-resident working in the city. And that's our situation, isn't it?
That's correct. COVID-19 threw the proverbial wrench in the gear here. So let me explain briefly, if I could, Your Honor, how this would work, how this does work practically. If you work within the city but do not reside within the city, you pay 1/2 of 1%, which is half of what persons would pay as residents also working in the city. Now,
by the way, that's me.
yes, it's me too, Your Honor. And so when a party the taxpayer files their income tax, they're permitted to allocate, which basically says you're not taxed for those days you're working remotely, not into the city. Now, there's plenty of taxpayers, if you file through TurboTax or a CPA or do it long form, where you can actually allocate and receive a refund for those days that you're not working. The misnomer here.
But I understand that. But the reality is, for the employer is going to be withholding as if I'm working every day that I work in the city.
That's correct, Your Honor. It's really the responsibility.
Let me ask the question, because you're probably getting prepared to answer it anyway, but I want to make sure we're talking about the same thing. I'm assuming an employer as big as Consumers has people that reside outside the city and generally work outside the city. Are they required to withhold from an employee, even if that employee only typically works a handful of days of the year in the city? Are they required to withhold as if the employee is actually working every day of the year for the city, or within the city, rather?
Well, that's a good question,
How does that work,
Your Honor? And so it's dependent upon the initial filing of the W-4. COVID notwithstanding, if a party, for example, works a portion of the year, they typically would have the entirety at each of their pay periods, their city income tax withheld, and at the end of the year, the tax year, they would make their filing and allocate and receive a refund back for all the days that they didn't actually work within the city limits. In fact, plenty of Consumers employees do that as a matter of course. But fundamentally, that is an operation that exists by and between the employer and the employee. You can imagine, Your Honor, the city doesn't have the capability or the manpower to know where thousands of employees, just take the hundreds of employees that work for the city, but the thousands of employees citywide, whether or not they're working 30 days out of the year in the city because of COVID, if they're fully remote, if they're in the city. And so as I cited in my brief, Your Honor, there's a symbiotic relationship between what the employer withholds and what the employee reports. Now, if that employee works with the employer and under the statute, if their status for the next tax year is going to change, Your Honor, they can file that required form under the City Income Tax Act and tell their employer, don't withhold any more funds from me because I'm not working in the city this year or the year upcoming. COVID, again, has been a bit of a boomerang here because all throughout the city, you have remote work situations where you may not be working in the city and working remotely, but the city has never once substantively prevented a taxpayer from allocating and getting credit for those days they're not working remotely. Consumers, employees do that consistently and have even pre-COVID, Your Honor. And so the notion that the city would have responsibility as a substantive matter to monitor this is a bit of a misnomer.
So for example, let's take COVID. I'm assuming Mr. Hofmeister worked the first 3 months or better of 2020, primarily in the city. And then COVID hit, he's working from home, no reason for him to come in. At that point, he could have gone to his employer and said, hey, I'm not working in the city anymore. I want to file an amended W-4 or whatever it is, so you'll stop withholding from my paycheck. Could he have done that?
In theory, he could, Your Honor. Now, the statutory provision talks about the December date of the prior year. And of course, in December of 2019, no one knew what COVID-19 was. And so we have this weird situation where you've got, as you mentioned, essentially the first few months of 2020, where everyone was working in their respective locations, presumably in the city, and having their required income tax withheld. But to answer your point directly, Your Honor, or your question, certainly the employee could have petitioned the employer to do that. It's not something that the city themselves have any control over. The other important point that I cited in my reply brief, Your Honor, is that the city has no record that Mr. Hofmeister has ever even paid city income taxes. And so you have a situation where someone's complaining about a refund having not followed the statute and actually filed income taxes. Our tax administrator has no record that he can ascertain. Certainly in years prior to this tax year. Of course, because of COVID, the filing deadline was extended from this month to June 1st, but there has been no filing by Mr. Hofmeister to this point. So even given the process by and between the city, the employer rather, in this case being Consumers Energy, and the employee, the city has no responsibility or ability to tell a Fortune 500 company with a full tax department how and when to allocate or to withhold from their employees' paychecks. Now, even assuming that the city did have such control, the sole remedy for them making that claim would be to either go to the City Income Tax Board of Review and said, hey, city, you need to correct this based upon X, Y, and Z circumstances, or file their appeal to the tax tribunal and make their arguments there. So in plaintiff's brief, Your Honor, they do note that they're free to frame their complaint in any manner they choose, but they're clearly not permitted to assert jurisdiction when none exists. And the Johnston case, the Apex Lab case, and even the recent unpublished opinion, Carter versus the City of Detroit, that's directly on point involving city income taxes, all those cases provided that there is not a basis for a circuit court to assert jurisdiction over an income tax appeal. And I think Your Honor's right on the money in talking about the mechanisms by which this is done, and that would be sorted out before the income tax board or the tribunal. So 2 final points, Your Honor, one of which is that the plaintiffs are simply incorrect in trying to argue that the MTT has only ousted jurisdiction from the circuit court over property tax matters. The Jackson Community College case, again, was a state income tax case. And given those circumstances, there's no way under 3 separate statutory sections and all the case law where plaintiff doesn't cite a single case where a complaint over city income tax was adjudicated outside of the tribunal, that this fundamentally has to be a case adjudicated before the tribunal, the Tax Tribunal Act, the City Income Tax Act, our Supreme Court, and other published opinions both before and after the 2000 Honigman decision all support that argument. And this is simply a square peg in a round jurisdictional hole, Your Honor. And for those reasons, I believe plaintiff's suit should be dismissed, and the proper forum for redress is before the Michigan Tax Tribunal.
Thank you. Mr. Ellison?
It is me, Your Honor. It's been I'm sure you don't remember, but I was before you about 9 years ago or 8 years ago, I think. It was a long time ago on a case. I saw you for about 5 seconds and we settled. I guess you scared the hell out of the other side. So it's been a while since I've seen you. So good to be back before you here today. So a couple of points right off the bat. I want to make very clear. With all due respect to Mr. Haggerty, he's wrong. So one of the things you asked him just now was, is it possible to amend your tax forms to change your withholdings for the city? The answer is no. And we've actually alleged that in our complaint, in that I've had conversations with the folks at Consumers, and they've been trying to do that with the city and have been unsuccessful. And that's one of the big issues of why Consumers Jackson is unique. There are more than just Jackson that has this circumstance that exists. Jackson's unique because they have a really big employer that's been trying to do the very thing Mr. Haggerty claims that should be able to be done, and the city treasurer refuses to do it. But let's start a half a step back for a second. There is no dispute, and I have not heard today or in the briefing in any way, shape, or form that the city is entitled to non-residential income tax when the non-resident is no longer working within the city itself. Consumers Energy, as a matter of corporate-wide policy, not one or two or a handful of employees with unique job circumstances, basically all of One Energy Plaza is vacant right now, because everyone was assigned back to where they worked before, assigned actually and still today, and will be to be assigned in their respective homes. It's no different than a job transfer in and of itself. You no longer work in Jackson City at One Energy Plaza. You now work at a different location. Now, so we start from that premise, and that's right on. I start on bottom of page 1, top of page 2 of my brief. And that this is the rare circumstance where me as a civil rights attorney and the state of Michigan and I get along and actually agree, which is a rarity. I should buy a lottery ticket. But that being said, then what happens then is what happens next. Mr. Haggerty keeps arguing that we should have to exhaust our administrative or state law remedies before bringing a 1983 case. The federal courts, including the U.S. Supreme Court, no fewer than 9 times has said you do not need to use the process, i.e. exhaust your administrative remedies in order to bring a 1983 claim. Now, ultimately, the court may disagree whether this was a civil rights violation under 1983, but the ability to bring that claim belongs within a court. I could either bring it in federal court or I could bring it in state circuit court. Each court has concurrent jurisdiction. I bring it here because there's a second principle which we didn't have to talk about, but is that tax issues involving any way with tax have to be dealt with as a matter of comity in state court systems. Now, a couple of points. right off the bat is this a tax refund appeal? The answer is no. Nobody has filed any documents or filed anything to seek a refund and was denied a refund. But the whole point of this is not that we're being denied a refund, but in fact being denied the ability to keep the money that that belongs to us. The state law is very clear. If you don't work in the city, you don't pay the tax. The city cannot implement a tax now, refund later. Because even if, let's just assume for the sake of argument, everybody files for a refund who's entitled to it, the city has denied every one of those folks the time value of their money, interest. They're not returning any interest payments on money that they were not allowed to extract. So we've brought 3 claims. One is a due process exaction claim. It's premised on a case called Nelson from the Federal Court of Claims. Count 2 is a takings claim, which is primarily based on a case called Nick versus Township of Scott. And our third count is a state law claim called Assumpset. So the question is, where are those 3 claims should be heard? Now, what my brother counsel keeps saying is you don't get to bring those claims until you run through the appellate process. The appellate process is not the exclusive means to do this. There are other mechanisms in place. And frankly, even if we went through that process, we're not going to get paid the interest that we believe that we're due and was denied and was taken from myself or on behalf of my clients that way. So the question becomes is what should we do here? This is a very simple case, and every path leads back to this court having jurisdiction. For example, if we acknowledge that this is a class action case and it's some near future point, we're going to be bringing a motion for class certification. When we bring that motion as a class, we brought the case as a class. By bringing it as a class under Dix, the Supreme Court's extremely clear. You have to bring all class action lawsuits within the court, the circuit court in the county. We've done that. If we talk about, he keeps talking about the tax tribunal. The case law is very clear. The tax tribunal has no class mechanism in place to be able to handle this. Now, the second part of this is...
Does the tax tribunal have any remedy in place for someone who's complaining that money's being withheld and shouldn't be?
No. And let me qualify that. When I say no, I want to be clear about that. In theory, because I can't find any record of this, because I can't even find a record of there being an income board of review in the city of Jackson and who serves on that board. But let's assume for the sake of argument there is. And let's just even assume that they will give all the refunds that they're entitled. They're denying the city has essentially given itself a year of interest-free loans.
No, I understand that point. I mean, the refund remedy is adequate to get you your money back, but it's not adequate to stop withholding long before you ever get to the issue of refund. I get that.
Correct.
But my question was, is there any kind of remedy with the tax tribunal that would allow you to get, not as a refund, but to actually stop the process of collecting the withholding before you get to the end of the year and you're talking about a refund?
The answer would be no. And the reason being is in order to activate the board of review, income board of review, you have to file a petition after the tax year, get denied there, and then file an appeal to the tax tribunal. So there's no direct cause of action into the tribunal for a ruling that says what Jackson's doing, say Jackson, some kind of idea that Jackson be ordered to stop the withholding process against employers. There's no mechanism in place to do that. The tax tribunal essentially acts like a for lack of a better word, because there is a back of a better phrase would be, they're essentially like a court of appeals from this court. You can't go to the circuit or court of appeals until you go through the first step of the process. The problem is we can't even get in the first step of the process until the city takes all the money they've been taking for the last little less than a year in 2020 and continues to take this year. Now, my other counsel keeps saying you can change your deductions, you can change your designations of how often you work in the city. We've specifically pled in our complaint that they're not doing that and or are refusing to do that. We've included
who's refusing?
the city treasurer.
Why is it up to the treasurer? Why wouldn't consumers tax department say, well, for example, when an employee gets transferred out of the city, I can't believe they continue to collect Jackson City income tax from that point forward. Why is this any different?
Under CETA, the statute here, the employer is the trustee or agent for the city. Here, Consumers Energy has asked the treasurer to allow us to stop collecting money on behalf of their employees, and the treasurer has said no. I've included an affidavit in there that outlines that we will get evidence of that through the use of discovery. Now, that's completely opposite of the assertion Mr. Haggerty just made to the court, but that's beyond the scope of the C4 or C8 motion that's here today.
I get that. I'm just trying to look down the road.
Sure.
So, granted, with COVID and a lot of people working from home, we've got a much more challenging situation. But long before COVID, Consumers Energy would transfer employees mid-year from a Jackson location to something outside of Jackson. Are you telling me that when they did that, they still kept withholding for the balance of the year for that employee?
I can't speak to those particular employees, but I can speak to the fact that when Consumers Energy sent everyone that essentially working from home is still working in Jackson from the treasurer's standpoint. That's our allegations, and that's what our understanding of the circumstances are. And we've spoken to folks at Consumers and confirmed the same as well.
So if you're remoting in from your home to your computer connection at the headquarters, could that very well constitute working in the city? When I go home, and I've had to work from home a few times since COVID, I have a computer that allows me remote access to my desktop computer in my chambers.
Correct.
So I can go in, I can look at from home exactly what I can look at when I'm sitting here. Now, I use that a little bit, but I also conduct Zoom hearings on my home computer that I guess my image gets transmitted down here to the courthouse, but I'm not here. I'm out in Clark Lake.
So I guess sort of, not to make a flippant of this, but I'm happy to be your lawyer in this class action case. Congratulations. Right? But setting aside being flippant, the key, I guess the point is that is a position that Jackson could take in this case, arguably. It would be contrary, though, to what the Michigan Department of Treasury has issued as guidance, which is part of, that's part of it. There's a link to that on the bottom of page, starts on the bottom of page 1 and goes to page 2.
So I hear what you're saying. So here's where the city is involved, is there's a dispute over, is this person actually still working in the city or not? The example that I gave you earlier, well, what happens when Consumers transfers someone working in the city to a different location? And I suspect the answer to that is pretty clear. As soon as that person gets transferred, they stop withholding city income tax.
Correct.
I'd be shocked if it's anything different.
I'm guessing Poppy, when she moved out to California, did not continue to pay city income tax as the former CEO of Consumers Energy. But the same time,
but I'm talking about somebody who's still working for Consumers and gets transferred.
I guess the short answer is from our understanding, at least as to consumers who are consumer employees who are working from home, the city treasurer's position is that they still need to collect that tax and then refund, and then if the worker believes they're entitled to it, to seek a refund. Now, and I want to point out one additional fact that we're not hearing today either is that I can assert to you is that the city treasurer has threatened penalties against consumers if they don't continue to withhold. Now, I can't give you that information right now because I can't as a pre-suit case, compel consumers to hand over those communications without a subpoena. Our hope would be is that we could get through this motion today. Jackson would be ordered to argue or to answer the case. I would then be able to secure that evidence to show, in fact, that this, and again, with all due respect to Mr. Haggard, I don't mean any disrespect to him, but this golly shucks, we're just doing what's best for the city routine is actually an inaccurate statement of what the city treasurer is actually doing as it applies to CETA, because the end result, and of course it makes good sense, cities are struggling for money right now. I get it, but you can't take money from people you can't take it from. That's a wrongful exaction under the 14th Amendment. You can't take money that doesn't belong to you. And I would argue, when talking with my co-counsel who's on the screen here, we've batted this back and forth and back and forth. You know, kind of the analogy we try to put to this would be is, you know, you pay every year, at least I'm supposed to pay quarterly income taxes, or an employee pays a payroll deduction every payroll period for taxes that get paid to the federal government, right? What's the difference between here, where I'm arguing a constitutional violation, and like a federal income tax? Well, the difference is that I have the mechanism, the means, when dealing with the IRS through my employer, to tell them how much to take, including almost zero, and I have to pay at the end of the year or on a regular basis. I get to control that, how much gets paid in. Our allegation here is the city treasurer is telling Jackson, you're going to continue to collect city income tax for us. We're not going to change that process. And if these guys at the end of it think that they're entitled to a refund, they can ask for a refund. But in the meantime, the city gets 7, 8, 9, 10 months in 2020 of an interest-free loan that continues to go forward, and denies in this case, we think there's at least several hundred, if not more than 1,000 employees who were denied the ability to get money when they needed it most, which would have been, during a COVID pandemic. That's in the city's pocket, generating interest or being used or being utilized, and not in the pocket of the individual citizen who happens to not live in the township, or in the city anymore, and also doesn't work in the city anymore. So I guess what I'm asking this court to do is the question today that it gets jumbled with the arguments from the city side of things is, what court, you can't, the case law is clear. Jurisdiction is not based on the case that's in front of you. It's based on the class of cases that are in front of you, the type of cases. Federal civil rights cases do not get brought in the tax tribunal. It's precluded, the tax tribunal does not have the authority to decide constitutional issues. Now, there is a little exception, and that's the part that the city has harped on, to say, well, if it's got a twinge of constitutional issue, we will allow the tax tribunal, basically that a taxing entity is acting arbitrary and capricious. We're not arguing arbitrary and capricious. We're arguing unlawful exaction. And those cases have never been allowed, and a takings claim has never been allowed to be adjudicated in the tax tribunal, because constitutional claims belong in courts, and the Supreme Court has said as much. So I think the best outcome right here, right now, is, I'm not saying we're going to win the case as a whole on the matter of the merits so far. I'd like to. I certainly would hope to. That's why I bring this case. The question right now is, who hears 2 1983 federal claims and 1 state law assumption claim? And the answer has to be you, and I say you, the Circuit Court of Jackson hears this. And to the extent that CETA says you can't hear federal claims, that is preempted. There's a case called Perez versus Campbell, and that citation is 402 U.S. 637. The Michigan legislature and the city of Jackson cannot preempt federal claims in court. That would be a violation of the Supremacy Clause. The federal Congress has allowed civil rights claims to be brought without having to exhaust or otherwise use the process the local government would prefer. Now, ultimately, if we went on the merits, that's a totally different question than what we hear today. Where do we bring these claims? They got to be brought somewhere. They're not precluded as a matter of law because there's no exclusive exhaustion requirement. They have to be, it can't be brought in the tax tribunal. They can't be brought in the district court. And I can't bring them in federal court. You're it. And so even, I guess, one last point, and I hit it a little bit earlier, Judge, and indulge me here. Even if, let's just even assume for the sake of argument, everybody filed a refund through the administrative process going forward. At minimum, all of these folks, at least under our claims, would be entitled to interest on that money. And a refund of that interest for money that was exacted, that was not allowed to be exacted, should be paid as a form of compensation for having taken money that didn't belong to them, or could even remotely, or even on the longest stretch of the imagination, continue to extract from the citizens and workers who are non-residents who are no longer working in the city of Jackson. Unless the court has
thank you. Anything further, Mr. Haggerty?
Yes, if I can just respond to a couple points briefly, Your Honor. One of which deals fundamentally with the procedural construct that Mr. Ellison provided. And that is, he still refers to this purported mandate by the city income tax administrator. The CITA is clear that the relationship in withholdings is by and between the employer and the employee. For example, take it outside of the context of merely consumers, but how is the city to know the remote status or not of every other individual employee working in the city, potentially remotely, and dictating how, if, and when the employer withholds from that particular employee's 2-week pay period or weekly pay period city income tax withholding? It's an impossibility. And so this notion that the city can wave a magic wand and dictate what consumers does, I think, is a fallacy. Even if you assume that to be true, Your Honor, that this particular decision or order of the income tax administrator resulted in these withholdings, which the city very much contests, Section 93 of the CITA makes clear that the redress for that is before the tax tribunal. So in sum, what plaintiff's counsel wants to do is go on a fishing expedition to find persons who may or may not have paid income tax yet, because the filing deadline's not passed. It's June the 1st, and figure out what potential refund they may or may not have based upon withholdings that their employer undertook. If consumers made that decision, it was theirs to make under the City Income Tax Act, not the city's. And the employee had a duty, as cited in my brief, to make that report if they didn't want the withholdings to go forward. As Your Honor mentioned, if someone stops working, for example, in the city limits, still works for consumers in Blackman Township or Leone or somewhere else. And so this is really calling a duck a cow in large measure, Your Honor, because, as Mr. Ellison admitted, there is no mechanism for a class suit in the tribunal. So it behooves plaintiff's counsel to move forward on this case to try and flood the court with, in his words, hundreds, maybe thousands of taxpayers that all belong before the tax tribunal. Any aggrieved party can make their complaint just as they'd be filing a city income tax appeal. If you don't like your tax assessment for the year, you go to the Board of Review and on to the tribunal. This is really no different, Your Honor. The mechanism is simply the City Income Tax Board of Review and then the tax tribunal. But there, in Mr. Ellison's argument, I didn't hear a single citation to a case that would give jurisdiction to this court over a city income tax appeal. And I believe the jurisdictional mandate of the Tax Tribunal Act and CITA is clear and has to result, in this case, being adjudicated on the merits in the tax tribunal, not before your honor.
All right, gentlemen, since it's clear that no matter what I do, another court is likely to have the final word on the issue, I want to take a little bit more time to study now with this perspective. I'm going to take it under advisement. I've got a stipulated order to extend the date to file a motion for class certification. I'm assuming you want me to sign this today.
Please, Your Honor.
Please, yes.
Okay, I will do that, and I will take this under advisement and issue a written decision, gentlemen.
Judge, just to be clear, if I could, I don't know if you made a note, I did cite the case that I wanted you to take a look at about preemption and class, federal supremacy is Perez versus Campbell.
I assumed that was in your brief, but it's not.
It was not. It was not. That's why I wanted to bring it up today. It's 402 U.S. 673 at 651, and that's a 1971 case.
All right, I've written it down.
Thank you, sir.
Thank you.
Thank you, gentlemen.
Thank
Good
you, Your Honor.
afternoon.
Appreciate your time.